Hello class, my name is Brian Smith, instructor as well. Today we're going to be going over the Fourth Amendment and the lawful use of force. If you're wondering what I'm doing in the background, I've got a PowerPoint that I've created for this presentation just to make sure I stay on track. The Fourth Amendment defined is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now that's the exact definition of the Fourth Amendment. We have a couple of cases, for example, Connor versus Graham. That is a case where Mr. Graham, the diabetic, went to the store looking for orange juice and not wanting to wait in long lines, gets agitated in his condition. He is suspected to be, doing things he's not supposed to be doing. And Officer Connor believes he is acting suspicious and makes an investigatory stop. Ultimately, what happens is the officers wind up using force to gain compliance against this individual, and then later Graham files a suit for excessive use of force. The Fourth Amendment actually protects the citizens and officers, and officers are required. The Fourth Amendment protects citizens, and officers are required to use objective reasonableness to determine when to use force. Objective reasonableness simply means, would another officer act the same way if they were in my shoes responding to the same incident? Force must be reasonable in any situation or warrants justification. Would another officer respond the same way as I did? An example might be perhaps a man weighing 350 pounds and is 6'5". He's acting belligerent and has been known to have violent tendencies from his past encounters with law enforcement. If you're wondering what I'm doing, my dog is right next to me and he's acting crazy. But this really, really big fella is acting belligerent, and he's known to have, a violent history with the law enforcement. Police respond to him at a gym where he is reported to be, and whenever the police arrive, they observe him throwing large objects like maybe the weights around in the room, and the officers must use force to prevent injury to others when he just flat out refuses to comply with any kind of instructions. Well, that's the example. You got a really large guy. He doesn't necessarily have anything in his hand right away, but the police see him throwing these objects around the room. Well, that's a reasonable objectiveness. Should they use force? Perhaps. Moving on. Tennessee versus Garner. That's another case in point. I believe it was 1985. Garner is suspected of breaking into a home. He's a young boy and is fleeing by jumping over a fence. The officer uses deadly force to stop him, but it doesn't establish possession of a weapon or any particular threat at all. He's just jumping over a fence, and he's suspected of robbing a home. Garner's father actually files suit for a constitutional violation of his son's rights. The threat to yourself or others must be established, and just because someone is suspected of burglarizing a home doesn't necessarily make them a danger to the officer or others. An example of that would be what I've concluded. An officer during a routine traffic stop observes the driver reaching for something at his side when approaching the driver's window area. Officer then fires his weapon, killing the suspect, believing him to be armed and attempting to draw a weapon from his side, and it's done without ever being able to identify any kind of threat at all. Force, as defined by the official code of Georgia, here where I live, is defined as a physical force used to compel an offender to take action against his or her will, or to prevent an offender from taking action that would be damaging to themselves, other persons, or property. And we have a few things in Georgia that I like to use just to simply justify any kind of use of force. Number one, you got to have an ability. The ability is simply just a state of being able. Does the person have the means necessary? Second would be opportunity. It's a combination of circumstances contributing to certain action or inviting a certain decision. Does that person have the opportunity? They have the abilities through simply, being of sound mind and body. They are, they're not necessarily in a wheelchair, 30 feet away from me. They have the ability because they are standing right in front of me. And they're living, breathing, have two arms. They're there. Opportunity may just simply mean that they're in close proximity to me. They have that opportunity. They may be standing there holding a weapon. And that opportunity is there, whether they take it or not. And then the third thing is jeopardy, which is an exposure to or imminence of death or harm. That simply means, am I putting it in jeopardy? So that ability and the opportunity that person has standing right there in front of me holding a weapon in his hand, well, is he putting my life in jeopardy, or my safety in jeopardy, or someone else's safety in jeopardy? Not yet, but he could. Then you got to take into other considerations such as age, size, male or female, the skill level of that individual, perhaps even reaction time. So that pretty much concludes what we wanted to cover today, the Fourth Amendment and the use of force. We defined what the Fourth Amendment is, and we covered what the use of force is when it's necessary and how it's implemented and constitutionally upheld in law enforcement. Thank you for watching my video.